Good morning and Merry Christmas.
Good morning.
I'm Roland Waller, the attorney for Roland Waller, the trustee of the Clifford Pruitt Testamentary Trust. To sort of help me or keep the record clear, I'm going to refer to my position as Pruitt as far as that's concerned. I'd like to reserve 5 minutes for rebuttal.
You got it.
This is the underlying matter is that Pruitt gave a second mortgage to Mr. Richard DeBoard. Mr. DeBoard had previously executed a first mortgage to HSBC, and he faulted in his payments to HSBC, and they filed a mortgage foreclosure action in 2007. They included Pruitt as the second mortgage holder. The case proceeded to trial in 2013, and after a trial, the judge entered a final judgment finding in behalf of Pruitt and also DeBoard. After the judgment was entered, DeBoard or Pruitt filed its foreclosure action on its second mortgage, which was now prior first mortgage, and foreclosed out DeBoard into title to the property. In 2017, U.S. Bank then filed a complaint to foreclose its mortgage, which is the same one that it previously foreclosed upon, and the final judgment was entered against them. The initial complaint was filed by Caliper, and Caliper was the servicer, and the complaint alleged that they were proceeding with an attorney-in-fact. And so they proceeded. We had discovery. Later on, an amended complaint was filed. This time it was filed by Fay Servicing. The amended complaint, which we're here on today,
It was verified by.
beg pardon?
The amended complaint was verified by Fay Servicing. It wasn't actually filed by Fay Servicing.
That's correct. It was verified. That
That makes a big difference.
yes. Okay, it was verified by them. And so, however, the complaint, whenever you look at the complaint, there's no reference, no allegation that Fay Servicing was a servicer or had an attorney in fact. They simply verified the complaint.
And there are case laws, and that's sufficient.
That is sufficient to state a cause of action under the rule of procedure. That's correct. Then Pruitt filed a motion for summary judgment, as did the plaintiff. The only evidence that we raised res judicata and estoppel in our answer to their amended complaint.
And
And
the
then
same issues litigated in 2013 as are in this case.
that's correct.
Because I was under the impression that in 2013 Waller was defaulted.
That's correct. We were defaulted, but the final, yeah, that's correct, Your Honor. We
So
were
the
defaulted.
main priority issues really weren't litigated at that time, as with respect to Waller.
Well, rarely do you, in a foreclosure action, an answer to your question is you don't litigate that as far as that's concerned. And I would cite the Seminole case as far as saying that whenever you have a final judgment, it litigates all issues, whether or not that could be raised as far as that's concerned, as far as res judicata is concerned. And in the 2007 pleadings, they said that their mortgage was superior to Pruitt's. However, and so that was an issue that could have been raised or was raised in the pleadings, and the final judgment addressed all issues that could be raised under the Seminole case.
Can there be a subsequent foreclosure filed after the first one was unsuccessful?
Well,
why couldn't there be?
Well, then we filed the second one under this amended complaint. And whenever they filed that, they again asserted that they had priority. Now, we look at the issues as far as res judicata. Now, they can't, the same issue, the same parties, the same issue, and the same proceeding, which is the priority of the first mortgage and Pruitt's position, that those are identical. That's the issue. Now, of course, we're all familiar with Singletary, but that's between the lender and the borrower when you have a subsequent default. That wasn't the issue that was litigated between, in the 2013 case in Pruitt. And so it's the same identical parties and the identical issue. And the court ruled in behalf of Pruitt, and that we were very active in that litigation. And he ruled in our behalf that we go hence without day the final judgment. So the other, besides the res judicata that was raised, we look at the lack of standing, and that the only thing that they filed in support of their motion for summary judgment was an affidavit that was executed by Fay. Well, they didn't offer, and it wasn't pled that they had the authority. They simply verified the complaint. There's no authority for them to say they had a power of attorney, they were the servicer, or anything. They simply verified the complaint by saying that they were the attorney in fact. And so then they filed the affidavit, and they say in the affidavit that they're the attorney in fact. The power of attorney was never offered into evidence. No evidence whatsoever of any agency was ever filed with the court. And this was preserved, and it was objected to strenuously in the lower court proceeding. In fact, the discussion with this issue about them verifying the complaint, whether or not that was sufficient, was in the transcript of the hearing with Judge Berg. And so it was argued that, well, this case, the Lakeman case, I think it is, that says that you don't have to have the power of attorney to state a cause of action to verify the complaint. However, Rodriguez and Elliston and any number of other cases said that you do have to prove, at some point you got to prove the power of attorney or the agency relationship. Here, there's nothing in the record, where that Fay has any relationship to
Isn't that the whole point of the Plagerman? The point of the Plagerman case is you don't have, when a servicer is signing as to authenticate, to verify the complaint, nothing more is needed.
State a cause of action, Your Honor.
The plain language of Rule 1.110 does not require a servicer to file evidence of the complaint, proving that it has the authority to verify the foreclosure complaint.
I agree with that.
I
However,
hope so. That's our law.
well, you're right. Well, that's not my own.
Judge Black was on the panel.
Well, I agree with that. However, that's not what we're stating here. Also, if you look at Rodriguez, it says that this is that's not an evidentiary issue. This is an evidentiary issue.
Well, the whole thrust of your first argument is that there's something wrong with Fay's role in this because of the lack of agency or some other document to show who they are. And I'm just saying that under Hageman, the first issue you've taken up on this appeal is refuted by the holding in Hageman, among others. And the Petroff case, same way.
Your Honor,
There's no requirement that they do anything other than sign.
to state a cause of action. Yes, Your Honor. That's under the rule of procedure.
Because the complaint is brought in the name of the plaintiff in this case, not like some of the other ones that you cited, the Russell case and the Elston case and some of the other ones.
What about Rodriguez provides that you have to prove or put something in evidence as far as a power of attorney is concerned. They didn't even allege that they had the power of attorney. You look at the allegations in the amended complaint. It doesn't even allege that they had a power of attorney. And it's not required under the rules as far as the state of cause of action. I'm 100%. But at some point you got to prove that. And there's no evidence whatsoever that they did have a power of attorney. So it just simply says under the rule, it must be verified. Okay, you don't have to have the power of attorney to verify the complaint. I'm in agreement. That's what that case holds. If you look at, but if that's not on a motion for summary judgment as far as evidence, where's the evidence of the power of attorney? It was never put a record, not even referenced, and they didn't even allege that they were an agency, which in order to bring a cause of the statute's clear is if you're going to bring a cause of action on behalf of someone, it must be specifically pled, which it wasn't specifically pled, nor was it proved. So I submit that they didn't prove standing because they didn't show any authority for failure to bring the cause of action. Simply because they verified the complaint doesn't give them the right to prosecute this action, because they've got to prove that they had the power of attorney, which wasn't even alleged in the pleadings. So the issue as far as the standing is that they don't have. In fact, if you look at the transcript, Judge Byrd questioned that as far as saying, and the appellee said, well, I've got a case that says it's not necessary. But if you read Rodriguez, it says that you have to put into evidence the power of attorney to prove that you have the authority to bring the cause of action. And so I submit that it should be reversed on that basis, and that there's no evidence whatsoever to show that they have the authority. And further, as far as res judicata, and that under the Seminole case, that all these issues were decided in the 2013 case, which are the same issues that we litigated in this case, and that between Pruitt and the bank, all the issues are the same. The same parties, the same priority as far as the mortgage is concerned. Thank you, Your Honor.
Thank you, Mr. Waller. Your rebuttal time if you want to use it.
Your Honor, to make use of the court, Attorney Ian Hudson here on behalf of plaintiff U.S. Bank Trust National Association, not in its individual capacity, but solely as trustee for the LSF 8 Master Participation Trust. Your Honor correctly notes that under the Hagman and Petrov rulings, we need not attach a relevant power of attorney to the complaint to state a cause of action. In order to obtain summary judgment, we do need to satisfy the requirements of authenticating business records and establishing the relationship of servicer in that instance. And our affidavit of indebtedness lays out that procedure effectively. It clearly states that Fay Servicing is the servicer on behalf of the plaintiff, in that matter, U.S. Bank Trust. Mr. Waller's reliance on Rodriguez and Elston and Russell is misplaced because, as Your Honor correctly noted, those are cases where the servicer is bringing the action in its own name on behalf of the real party in interest. That's not the case here. Fay Servicing merely executed the documents on behalf of the real party in interest, U.S. Bank Trust. And the Hoke case that Mr. Waller cites to in his brief also stands for the proposition that affidavit evidence can support a finding of authority and servicer relationship. In that particular case, the affidavits before the court indicated that a different servicer was the servicer of the loan rather than the party moving for summary judgment in that case. So the record created an issue of material facts such that the servicer relationship was not established. So I don't think it's our argument that it's not in dispute that Fay Servicing established its relationship as servicer and has proven standing both at inception of the case and at its conclusion with the affidavit of indebtedness attached. As to Mr. Waller's second argument of res judicata applying, case law is that's simply not the case law of Florida. There's a litany of cases that stand for the proposition that a separate and distinct default creates a separate and distinct cause of action. If this were a mature loan that we were suing on, then it would be the same issue. It would be the entire mortgage being sued upon, as Mr. Waller claims. But the 2007 case was sued on a default date in 2007. The 2017 case was sued on a default date of January 1st, 2013. That alone creates a separate cause of action, if not the same issue that's being litigated. In addition to that, the language of the final judgment contains no findings of fact as to that issue. Reading from it directly, findings of fact as to real party and interest, as to agency relationship, as to conditions preceding, and as to amounts due and owing, but it makes no mention of lien priority. And so even if we did not have a separate distinct cause of action based on the default date, the issue was not litigated and resolved in the 2007 action. So res judicata is inapplicable in this case. And apologize if I talk too fast there, but if the court doesn't have any questions or concerns, then I yield the rest of my time.
Thank you, sir.
Thank you.
Well,
Thank you. I read from Rodriguez versus Wells Fargo. The bank therefore failed to prove that it had standing as a holder of the note when it commenced the action. Further, the bank failed to prove that it was a non-holder in possession of the note with the rights to hold. The bank introduced no power of attorney, pooling and service agreement, or other evidence to show the real party and interest authorized to bring this cause of action. Consequently, the bank failed to prove it had standing against the foreclosure action. They relies strictly on an affidavit that they signed that said that they were the attorney in fact. They didn't introduce, attach, whatever, it's not even referred to in the pleadings as far as having a power of attorney, as far as the to be able to proceed and to enforce the promissory the litigation. By the way, all of this is we talk about strictly not a servicer. It's not alleged that they were the servicer. The evidence or where they verified the complaint, they said they were doing that pursuant to a power of attorney. The affidavit that they filed also said that they were doing it pursuant to a power of attorney. However, no power of attorney exists. Therefore, I submit that there is no evidence that supports their ability to sign an affidavit under a power of attorney if the power of attorney has not been introduced into evidence. As far as the argument about res judicata and the subsequent default, Pruitt was not arguing, was not the issue with Pruitt and the 2007 proceeding was priority, whether we had it as far as that's concerned. They alleged that their mortgage had it, was prior in interest. And so under the same allegations are in the 2013 case, which is the same allegations, same parties or whatever. And so under the Seminole tribe of Florida versus the state of Florida, they hold that the final judgment is the same that covers any issues that could have been covered arising out of the same transaction. I submit this is identical and certainly is it adjudicated any issues that were raised, in particular on all four corners. The subsequent default was between the board, borrower, and the lender, not between Pruitt and the lender. As far as that's concerned, it was simply the priority. And so the judgment of foreclosure should be reversed. Thank you.
thank you, Mr. Waller. We are finished today's business and we have a recess.
All rise.